Yeah.
have a seizure.
So, do you know anything about this cannabis film festival? What kind of movies are you going to, or would be screened at a cannabis?
you like to? We're going to start your 3 minutes over again. You don't have to repeat anything.
Please don't repeat everything you said, though. As much as we
Okay,
love you.
yeah, all fresh information. Hi, my name is Joy Brown Meredith, and I'm the president of Main Street Palm Springs and a business owner in downtown Palm Springs for over 30 years. First of all, I would like to thank all of you for your many years of work on this project. It is just as annoying to me as you. So the thing is I think that when we were discussing this from a Main Street level, all of us were not perceiving it the way that actually it is. The one word adjacent to the building, that one phrase, was very misinterpreted by all of us. And all of us that I know and that I've spoken to about this, including the Main Street Board and merchants. So the idea of having to have the sign actually adjacent to the building itself creates this weird sort of pattern of walking rather than it being along the edge of the brick like it was before. And so the fact that today one of the discussions is the 3 feet from the curb is being taken out, I want you to understand how significant that phrase was in our understanding of this ordinance, because we didn't see it that way. We thought that the intention was that somebody couldn't put it in front of somebody else's building, not really that it had to actually be touching the building. So we do have some problems with this. There are other problems as well, like businesses that aren't right on Palm Canyon and how to deal with those sort of issues, but that's really a separate issue that's going to need some more definition. I would really hope that we can, persuade you to maybe review that again and see if the City Council would be willing also to review that, because I don't think that the intent of this is really what we were looking for here. Nobody wants to have ADA issues. So, we all understood all that, and we were fine with how it all appeared as far as our understanding of it. But now it turns out maybe we didn't really understand it. So I would love to talk to somebody on the Planning Commission in more detail about this, or walk the street with you and see how this is affecting the businesses. I just don't feel that this was exactly what we understood it to be, and I do take fault with that. I'm sorry if I misinterpreted it, and then I, in turn, told everybody my wrong interpretation of that, and I am embarrassed. So thank you for your time today, and just for all of your support for downtown. I can't tell you how much we appreciate this planning council and all of your support for downtown. Thank you.
Joy, would you stay close? I'm going to call you back before I close the public hearing.
Thank you very much. Yeah.
David Powell, I am the executive director of representing our organization, some of our members. I understand the need for an ordinance.
Let's see, Madam Chair, if you could, oh, there it is. Thank you.
Oh. I'm not on? Oh, now I am? Oh, I even sound better, Flynn. But I understand the need for an ordinance. I understand the need for the structure. I think that one of the benefits, there would be two, is I would encourage the city, whether it be planning or whomever, to have some kind of a workshop with merchants to better understand this, because people are having either misconceptions about it, they aren't unsure where it's going, and all they're doing is talking one-on-one with either code enforcement or whomever, and I think that that might work. We can do it in partnership with Main Street, the Palm Springs Chamber, Desert Business Association, and whomever. But I've had at least three members in the last 7 days contact me to say that they don't understand it and they feel that there is an issue with this ordinance. It's almost like it's new to them, which we know it's not, but also one of the main issues is when the shop is not right on Palm Canyon itself and is off the main street. The second is the noticing of downtown merchants, and I know I don't know what the requirement is. I know there's a certain amount for noticing of public hearings, but we don't see any other merchants here. People did not know about this meeting. I called the Palm Springs Chamber. They were unaware of the meeting around this. today. But even though it may not be the law, it may not be in what the practice is, it's the right thing to do to notice our businesses, and especially when it's on 1:30 on a Wednesday when some of them have other business things going on, whether it's a restaurant, et cetera. So I would encourage that kind of outreach to maybe be structured outside, and if you did do that, to the director, I apologize if I didn't know that, but I just think that there is opportunity to get more input to encourage beneficial feedback from our merchants. Thank you.
Lower this a little bit. Okay. Hi, I'm Gregory Goodman. I'm a businessman in Palm Springs. I have several businesses. Really confused about the whole sign thing. Being right next to the building at our main location, I see people, when it was by the road and, you know, in the red, it was fine. You know, we had it 3 feet away from the road and everything, and it was perfect. Now that we moved it right by the door, I see people tripping over signs everywhere now. I mean, it's become ridiculous. I have a business downtown also, and it's in the plaza. And the problem being there is it's in one of the little bungalows in the back, and no one would ever know we're there. And they're saying that I have to have our little sign right beside my door, so you'll never know we're back there. We have people, no one can ever find us. It's kind of hard. So that's my main thing, is the signage like that is right by the door. It's ridiculous. And then they want to make the signs all cookie cutter. I think that's not what Palm Springs is about. Palm Springs is about small businesses, you know, hardworking small businessmen and women. And making a cookie cutter, it doesn't show Palm Springs in its beauty. So that's all I want to say.
Joy, could I ask you to come back up before we close the public hearing? And this is just to ask you a few questions. One is, what is the problem? I've heard from this gentleman what some of the problem is. What's the logistical problem of it being next to the building?
Well, I think that it's creating a problem that we didn't have before, just in the way that the pedestrian traffic flow is on the sidewalk. So before, you know, it was off to the side there in the red brick area, alongside of the red brick, where there's other things, you know, there's like the benches, there's trash cans, there's tree wells. So, you know, if you could put your sign in a place where it wouldn't be also in a problem with those items. But so now, if you have it, you know, against the building, here's the building, here's the sign, and you have a bunch of this, you have people zigzagging up and down the sidewalk. The look isn't good. Before it was, you know, all along a row. It was a nice clean look to it. And now it's causing this weird pedestrian flow that is going to happen that I don't think was really intended to happen that way. So I just think somewhere along the line the interpretation got mixed up.
And did you have language? I mean, you understand that we can't change it, but we can recommend possibly to council. Do you have language that you would propose that we work with if we wanted to make a recommendation?
Say go back to the last language, right?
Yes, it would more
Or
take it
I
back
can
to
ask
the
staff.
last language. It wasn't really until I was alerted that this discussion was happening and that was going to be taken out that I even realized that there was a problem. I did not know that wasn't how that was. So I, in turn, retold this same wrong information to everybody, and that's why everybody was on board with it. So it wasn't until this I even knew.
Thank you.
And thank you. Thank you for caring, really. We're a lot of small businesses just trying to succeed. I know there's a lot of buzz downtown right now because of these other businesses that have come that have a special sign program where they get to do more than we do, and we're just little guys just trying to survive in a challenging economy. Thank you.
Thank you. That being, before we finish, does anybody else have a question for?
Madam Chair, just to follow up on that question in terms of what the desire was on the part of the Main Street merchants, I believe the comment was made that they'd like to see it return to what it was. The prior language was that a portable open sign may only be placed between a public entry into the retail space and the nearest fronting street or parking drive aisle. The sign may be placed in the sidewalk, public right-of-way, no less than 3 feet from any street or parking curb. What that did was that gave them the flexibility of placing it within the area that Ms. Meredith described in terms of where the street trees are and the street furniture is. And so it leaves the sidewalk area adjacent to the buildings open and then places those signs within that zone between the street trees and the curb, the parking curb.
Just before I close the public hearing, do any of the other commissioners have a question for the people that spoke?
I have a question for staff.
No, it's not for staff. I want to close.
The lovely gentleman in the red Hawaiian shirt. What would you propose?
Would
Why
you
don't you
please
come up?
come forward?
My question is, what would you suggest would be helpful for those businesses that are not right on Palm Canyon or like yours or hidden away? What would you want to see?
Well, I think we need to sign, the sandwich board out of the way. I mean, it can't be in the way, of course, but at least by the little alley going back so they can at least have a sandwich board right there. Because you can't tell that, we're way in back.
So did you have a sign like that before?
Yes.
And you're not allowed to do that anymore?
Not allowed to do that.
So, okay. So you can't really advertise your,
No.
your business? Okay.
So no one would know we're back there. So it's in La Plaza.
All right. Thank you very much.
Thank you.
Commissioner Hudson, you have a question for this gentleman. Can you
Come
stay
on
up here?
back. In terms of La Plaza, there's been a lot of new businesses there lately, which is great.
Right.
Have you spoken to the landlord about, there's how many shops are there? How many tenants are there?
It's full.
Yeah.
There's a lot.
So a couple dozen maybe?
Oh, probably.
So I've got to think, there's probably, I would hate to see, a couple dozen portable signs out here, secondary signs. And that's a specific case, but I would encourage you to work with the landlord.
Well, you know who the landlord is, right?
I know.
Okay. I've already asked them. They don't really want to do anything.
Yeah. At this point, there being no more questions, thank you.
Thank you.
I'm going to close the public hearing, and the matter is before the commission. I just thought this would speed it along if I made the motion with the language change that Ms. Meredith suggested and that Flynn so articulately put before us as a suggestion to the council, because the current language creates a tripping hazard, and for public safety that it be moved back to the way it was before.
Madam Chair?
And this is up for discussion, yes.
What was staff's or the council's reasoning behind changing that?
There were a couple of thoughts behind it. I believe one of the things was to have consistency in the placement of the signs so that they all occurred within the same zone up against the building. At least that's the way that I recall their discussion relative to those changes.
Commissioner Hirschbein.
Does your motion include the changes that the last speaker was requesting?
I'm not well enough
Would?
aware. Does it include it? It seems like it would. I don't know how this ordinance applies to La Plaza.
Yeah, looking at the previous language, it states that the portable sign must be placed between the entry into the business and the nearest fronting street or parking drive aisle. So in the case of the paseos at La Plaza, there is no street or drive aisle other than Indian Canyon. I'm thinking of the South Paseo. Okay, so either they have the entrance into the parking, which is at the center, so it could either be there or else on the Indian Canyon frontage where the Paseo comes out to Indian Canyon. So technically, that would be in conformance with the regulations if they were to put the sign in that location.
So if we changed it to this language, it would cover La Plaza as well as the downtown merchants and the other merchants that
Correct, it's just going back to
currently
the
impacted.
old language.
So the merchants fronting on Indian Canyon that are in La Plaza would be covered under this ordinance. but, correct?
Yes.
But the tenants in La Plaza fronting the pedestrian covered walkway that fronts the parking lot that runs between Indian Canyon and Palm Canyon, that's a private right-of-way. Does this cover that language as well? I mean, does this...
For those who only have frontage on the parking area,
Yeah.
they would need to put that portable sign between the entrance of their business and the parking area. They wouldn't be able to move it towards the Palm Canyon or the other frontage. It would need to be between the entry into the business and the parking area.
Okay.
What about the businesses in the courtyards?
So in the courtyards, it would be the nearest fronting street or parking area. So as we discussed with Mr. Goodman, that would either be the entrance from the courtyard to the parking area or the entrance from the courtyard to Indian Canyon.
But wouldn't that still be subject to the landlord also?
Ultimately, the landlord would need to sign off on sign permits.
So this motion has been made and seconded. Is there any more comment?
Yes, I do, Madam Chair. And this is a question of staff. So the square footage that let me back up a minute. The square footage that any individual business is allowed for signs, this, if they choose a portable sign, is on top of that. Is that correct?
That is correct.
So it's an extra sign a business is getting beyond what's permitted by the sign program.
Correct.
If a business, we have several of these along Palm Canyon, for an example, where there are pedestrian courtyards that go back in off of the street or upstairs, that particular landlord of that building with multiple tenants comes in and applies for a complete sign program. Is that correct?
That is an option that they could do, yes. Technically, in our code, any multi-tenant building needs to have a sign program. I will tell you that is not always the case, unfortunately.
So if the multi-tenant building has a signed program, can an individual business within that signed program then come in with a portable sign application?
Correct. If it's
they can, on top of the sign program, which many times can exceed the code as well.
Correct.
So they can get even more signage.
Correct, if they have an approved sign program.
So in many walkways, and I'll just use our examples here, and I think it was brought up earlier, several of our walkways have become very busy. And not only for the pedestrian path that's free and clear, as we call the walkable area, but people getting in and out of cars. So I assume keeping a 75 clear is, the 75 clear might not include, or does it include what we call like the trash and the trees and the benches?
No, it has to be exclusive of that area. So it has to be a 72-inch wide clear path with no obstructions.
Okay, so that we call the furniture zone between the curb and the beginning of the 72 foot, okay, is furniture and other objects at this point. So just so that I understand, and listening to both the public testimony and to staff recommendation, are there difficulties or liabilities in that furniture zone, which I believe is where the businesses want to put their sandwich signs, to put the sandwich signs there? I don't know if there's wind issues, blowing, I don't know what I'm just trying to figure out what the pros and cons of putting them in that area are.
The one con of putting that in that area is that we need to have space for getting in and out of vehicles. And so in the old language, it did say it had to be 3 feet back from the curb, and so that allows a car door to swing open and people to exit the vehicle. Other than that, I don't know that there are any other cons relative to putting it there. And again, you've already heard the pros of putting it there is that it maintains that consistent zone of the sidewalk up against the face of the buildings.
Thank you.
So we have a motion and a second. Are there any more comments on the motion before I call the roll? Call the vote. And
The motion is to go back to the original wording?
no, the motion is the staff report. So it is all of the changes in the staff report with the exception, and so that it covers what the main reason it came to us, which was that council wanted to give us back the review of sign programs and signage. So it covers all of those, all of the cleanup items that are in red that Flynn noted and that you saw when you read your staff report. But it also contains a recommendation to council that they look at a change to the way the portable signs can be placed, because the actual experience of placing them as they were proposed to be placed has caused a tripping hazard.
That's a recommendation to council.
It's a recommendation to council.
Thank you for clarifying that.
Oh, yes, I have to vote. This passes 6-0 with 1 absence. Okay, moving right along to our second item, which is, oh, this is a public hearing item. Oh, goodness, okay. Oh, no. Oh, okay, sorry, I'm reading at the wrong place. This is an amendment to the Planning Commission rules and procedures. And we'll get a staff report. Last time we passed certain changes, and we asked for changes that had to do with allowing the chair to call either an applicant or a member of the public back during non-public hearing items. And Flynn can get a staff report.
Okay, and the chair has already given my staff report, essentially. Last time we discussed that we would like to add language relative to giving the chair that ability to call people forward to respond to questions during non-public hearing items. And so what we have proposed is the language on page 6 of the rules and procedure. And essentially that lays out the format for discussion of non-public hearing items. In the middle paragraph, it states the chair may invite the applicant or members of the public to provide testimony or to respond to questions. And so that's the language that you requested to be added. And then one of the things that we felt was important to include there is that responses by the applicant or members of the public shall be limited to the questions posed by the commission. So this isn't a free-for-all public comment, but rather it's directed towards questions specifically requested by the commission. And so with that, we would propose that change. One of the other things that we would also propose is on page 5, we left out of the order of discussion under public hearings questions to the applicant or appellant by the commission, which you see there in red and underscored. That is something that we would also propose, just to clarify that any questions of the applicant remained under the public hearing portion of the agenda and are taken there as testimony. And with that, we would request your approval of these changes.
Can I have a motion and a second? This has been moved by Commissioner Callardine and seconded by Commissioner Maruzzi. Is there any discussion on this, or can we call the question? Would you please call the vote? These changes pass 6-0. And moving right along to new business, we have a discussion of proposed amendments to the Plan Development District Ordinance to implement the recommendations of the Ad Hoc PDD Committee. Staff report, please.
Madam Chair and members of the Commission, thank you very much. As you're aware, we have been through a lengthy process looking at proposed revisions to our Plan Development District Ordinance. You appointed a subcommittee late last year to begin working on those changes based on the final list of approved recommendations that the City Council has approved. So the subcommittee has been working over the last couple of months. What we wanted to do is have a discussion item with you. We would have included this on the study session, but the study session was already full this morning, and so we're having a discussion with you today. This is not in final draft format. Again, what we're looking for today is to just get your input on the work that the subcommittee has done thus far. In terms of the changes to the ordinance, we as staff have been working off of the base language that's contained in our Plan Development District ordinance currently. But what we are doing is incorporating the proposed changes that have been recommended by the ad hoc PDD committee. In terms of your handouts, the legal size document here with the yellow highlighting indicates all of the proposed changes that would then be incorporated in an amendment to our PDD ordinance. What I have done is in the draft version for your discussion today, you'll notice that there is highlighting in blue font identifying recommendations 1 through 9, for example, on page 1 of the draft revisions. And so what I wanted to do was identify in the sections of this draft amendment where we are incorporating those recommendations. And the primary reason that I'm doing that is so that we don't lose track of how we are incorporating those recommendations into the draft ordinance. What we would recommend that you do is perhaps that we go through this document page by page and discuss some of those changes. But before I do that, there are 2 particular areas where the subcommittee would like some additional input, and that is relative to the open space and lot coverage. I have a chart that I'd like to pass out to you that will help us in that discussion. And then the second area that the subcommittee would also like to talk about with you all as a group is language relative to gated communities. And I have a handout from the general plan that has the language relative to gated communities. So if you'll just give me a moment, let me distribute those to you now.
And as Flynn is distributing those, the subcommittee that was dealing with this is Commissioner Hirschbein, myself, and Commissioner Callardine. And we were joined by a member of the public for both of our meetings, Scott Bigsby, who had sat on the PDD ad hoc committee. Oh, and there is a member of the ad hoc committee, Marvin Bruce, who's here with us today, joining us.
So with that, let's go to page 1 of the proposed draft revisions. And one of the key changes here is under the purpose of the Plan Development District. These 9 points were language that was suggested by the ad hoc Plan Development District Committee. And so that whole section of the document has been revised to reflect the recommendations of the ad hoc committee. There are also some changes under the uses permitted section, but maybe let's just back up and look at the purpose if there's any comments or questions about that language there.
Madam Chair, I do have a question at this point. Flynn, I've seen how in our city PDDs have been used, and maybe in some cases not used appropriately, or maybe their intended purpose. In other cases, they've turned out marvelously. And I've also seen where specific plans have been used both effectively in the city. What I'm a little unclear on is, as we go through this PDD review here, and I don't have the benefit of the institutional knowledge, is when do we really want to use this over when do we want to really employ a specific plan? And what would be kind of given an idea of what that would be?
I don't know if members of the subcommittee would like to address that as well, but just from my standpoint, it has been our practice more often than not to use a planned development district for any type of specialized development. We've used specific plans very rarely. Looking at the downtown development, that is under a specific plan. We have several more throughout the city that we've used, but again, our practice has not been to use those very often. There are certain advantages and disadvantages under both approaches. What you saw proposed this morning was the use of a specific plan for golf course development. Just in my limited experience with specific plans, one of the benefits I see to those is that generally they tend to cover multi-phase development over a period of years and are often accompanied by a development agreement, which helps to ensure the development of the specific plan area. But again, it's a matter of practice for cities, and either tool is appropriate.
In terms of the PD process, the PD was used, the public felt excessively for the creation of small lot subdivisions, and where we didn't have zoning that would cover that. And one of the things that the PD subcommittee, which I was on, looked at was implementing a small lot subdivision ordinance so that we would have areas of the city where we could do small lot subdivisions, but that this particular instrument, which is to do some unusual or interesting projects, not be part of our ordinary zoning and not be utilized as frequently. So the one thing you will notice is that a single-use housing type is not part of the PD, and that the intention was that that would go through zoning. And I think, having sat on both subcommittees, the recommendation for a specific plan for golf courses, it's usually a larger development. It would be multi-phased. And the criteria that we put into the PD ordinance wouldn't necessarily fit the criteria, the development criteria, the golf course exception. I mean, in the same way it wouldn't have fit the downtown exception.
Okay. So moving on page 1 under uses permitted, there are some minor changes to this section.
Go back to the purpose for a minute. When we were talking about this in subcommittee, there was a discussion that the PD should foster improved architectural quality. And I thought we had words to that effect, maybe not in here, but did it show up someplace else?
Yes, it's under the criteria that we use to evaluate the applications. And so that's where that language appears.
Would you have an extra one of these?
Unfortunately, I don't.
I'll share mine with my colleague.
Criteria and findings?
Yeah.
Oh, yeah, there it is.
One of the questions, Flynn, was you were going to check on uses on number 5, whether the tribe still wanted to maintain number 5.
And I did have a conversation with Margaret Park of the tribe. She requested that we do retain that language. There was one minor change to the verbiage there, but otherwise, she did request that we keep that.
Thank you.
Let's see, while we're on the uses permitted section, one of the comments the chair made was under number 1 on uses permitted, we've added a second sentence there. It says a planned development district application is not intended for a single housing type unless combined with some type of civic, commercial, or institutional use. So that was one of the changes there to clarify the issue that it's not really intended for a single residential type.
And one question that I had when I was thinking about this later is if somebody came in with a, say, a small lot subdivision, but added one fourplex, how would staff deal with that?
We would go back to the purpose of the planned development district and see if it meets the intent of the purpose, as well as looking at the development standards.
Thank you.
Madam Chair,
Yes?
I expressed some reservations about this, I think, in the committee, as you recall. I'm working under the assumption that we will not be using this process for small lot subdivisions in the future. And I think we're going to say that when we go ahead and do the small lots. I can certainly see if someone wants to come in with a single type of residential unit that wants to violate or wants to change a standard for some reason in a particular development, PDD would be a way to do that, and then there may be a very good reason for doing it, that particular thing. I don't see why we're limiting this to, or taking away the right to do this for a single housing type. I know we want to encourage different types of development within PDDs, but I really...
I'm just looking at what council asked us to do. I mean, this went to council and went through a process, so it's come back, and it might be something that gets changed in the future, but did this
come out of our previous work?
Yes, yes. And it came out of the community's perception of excess.
Focused on small lots, I think.
I assume then that the reason was because there was a feeling that PDDs were being abused as relates to single lots?
Yes.
Because they were trying to not have to deal with the underlying zoning and just...
Well, and to some extent, they couldn't, there was no underlying zoning to deal with because we didn't have an ordinance that allowed for any small lot subdivisions.
I see. Okay, thank you.
And they were running out of R1 areas. Is that, I think that's...
Yeah. Okay, moving on to page 2, looking under property development standards. This is where we have made some additions based on the comments of the committee, some rather significant additions based on the comments of the ad hoc PDD committee. And these are development standards that we would use to evaluate projects in our staff report. So number 1, relative to building heights, we added language that building height shall conform to the requirements of the underlying zoning district or as may be permissible under the general plan. There is in the downtown design guidelines of the general plan certain areas where additional height is allowed, but otherwise the general opinion of the committee was that we should adhere to building heights, and so that language has been added. There's also been some language added relative to setbacks in number 3 to implement recommendations number 15 and 17. The idea is that the setbacks at the perimeter of the planned development should mirror the setbacks of adjacent properties so that you have consistency in terms of the setback from the street or at internal property lines between the planned development and adjacent development. Moving on to number 6, under property development standards, this is the regulations relative to open space. And as you'll see on page 7, number 6 on page 2 and continuing on to page 3, subparagraphs A, B, and C. This is the issue of what is private open space versus common open space. How much open space should be required for a planned development district. And this is one where we did request additional input from the Planning Commission on this. In the chart that I just passed out to you, what I've provided is a summary of open space versus lot coverage requirements in the existing zoning districts of the city. What you will see is that typically there is either a lot coverage that's used in our zoning districts or an open space requirement. And only in one instance, in one zoning district, is there both a lot coverage and open space requirement. So the typical practice has been to use one or the other in our zoning districts. What we are focusing on under the Planned Development District is on open space, and more importantly, on the quality of that open space. And so one of the things that we would like to establish is, of the open space that's required for a planned development district, how much of that could be private open space, or in other words, a walled area for a private residence, versus how much should be common open space, such as greenways, recreation areas, et cetera. And so that's one topic that we'd like to get some additional feedback from the rest of the Planning Commission members regarding open space.
Wasn't there a discussion about when it comes to private open space that it would be a function of setbacks and lot coverage, and when it comes to open space as a project, as a PDD-wide requirement, that be a separate number, separate calculation?
What I would recommend to you is that if you establish an open space requirement for planned development districts, you then also allow a certain percentage to be set aside for private courtyard areas for individual residences. Just to give you an example, we recently looked at the multifamily development in Miralon as a planned development in a study session. With that, they were proposing to do some courtyard walls around the residence, but maintained the rest of the open space as common open space for paseos, for park areas, shade structures, et cetera.
And would there be so there wouldn't be an individual lot coverage requirement in that case?
I don't think so, that you would want to do that. When you start separating out small lot development as a separate zoning category, in the small lot development, we have an individual lot coverage requirement and then also a requirement for open space, but that would only apply to the small lot development. Here, as a planned development district, we're anticipating that you are going to have either a condominium type of ownership or some type of common ownership, that you won't be developing these as individual small lots.
I agree with that. And also, with the setbacks, we'd also be looking at setbacks within the individual lots themselves, wouldn't we?
The individual units, yes.
Setbacks.
Yes.
Okay. And would that supersede or be subservient to the lot coverage, or you have to look at it kind of in conjunction?
No. Setbacks are a separate development standard, so they'd have to adhere to setback requirements and then any lot coverage or open space requirements.
The closest that we have here is the limited multifamily residential, where they required 50% open space, of which, of the open space, 60% of the open space needed to be, could be, or actually 50%, and they had a lot coverage requirement. It seems to me that we'd want some number, whether it be 40% of it open with half of that being individual, or, I mean, that seems to be, it doesn't seem like we're going to need in this lot coverage requirements as opposed to having a percentage for the overall development and then allow, if there's individual residential units, a portion of that to go to the individual residential.
I would recommend one or the other, that you either establish an open space requirement or else a lot coverage requirement. Having both is a little bit more challenging.
But I think if you do an open space requirement and then you say a percentage of up to so much of a percentage of that can be individual if they're individual units.
Correct.
And do you know what number, as I'm looking at most of the ones that have open space requirements, they vary between 30 and 50%. And had you thought through what the standard should be here?
I was thinking somewhere in the range of 45 to 50%, mirroring what we do in other residential districts.
So if we did 50%, of which up to 60% of that could be individual?
I don't know that we would want to go that high on the private open space within the development. I was
So
thinking
50%?
I was thinking either 40%. So let's say, for example, that you have 10,000 square feet of required open space. If you allowed 40% as private open space, then 4,000 square feet would be assigned to individual residences through some type of a wall, and then 6,000 square feet would be some type of common park, greenway, or recreation space. Just to put numbers to that example.
If we put in a number that's 45 to 50%, depending on staff recommendation for open space, and then of that, 40% of that could be used for individual open space. That seems to me from what we have here that would fit, and let it be staff recommendation as to whether it's 45 or 50.
Okay.
Did we have a definition of open space in this?
Yes, we do. I've got that at the very tail end of the draft recommendations. There's a number of definitions that we would need to add to support these changes to the Plan Development District
And I don't know if the numbers that I've thrown out work for people here.
It's a starting point. One of the things that I haven't done for you that I still need to do is to look at past developments in terms of how much private open space they've had versus common open space. And so that's an analysis I will try and get for you the next time we have this discussion.
So if we start with 45 to 50 based on staff recommendation, and then up to 40% of that individual or private. One other change that I think we should have here is in A, the last sentence in A should be a separate sentence, a separate paragraph.
Okay.
So that it's A on page 3, DA is protection of natural features such as water courses, sensitive land area, existing native vegetation, wildlife, unique topographical features and views to be required. And then on a separate item, open spaces shall be integrated into the overall design of the project, so that it's not just that sentence really requires integration and not just that it fit within the, it's not a natural features paragraph.
Could you change it so that the setback requirements satisfy your open space requirements on the individual lots, and that
They always do.
and that the open space requirement only pertain to common area open space, instead of trying to define a percentage for each?
I think you want to still have open spaces because there's a definition. I don't know that I would be comfortable with that, but
Seems like it's kind of arbitrary to pick up a number like that as a percentage of the overall open space. And if your setback requirements within individual lots or between buildings,
well, remember you're working with setback requirements that come out of the code, and those, depending on what's being approved, can be varied with the PD. On the interior, they can be varied, can't they, Flynn?
Yes, interior, they could be varied. It's the exterior that needs to remain as contextually appropriate to the adjacent properties.
Just a question on how, there's a real difference between open space, common, or open space, private, and there's a real difference between that and a dedicated public park. And I'm not sure if we're merging our common open space with really a dedicated open park. And let me give you an example of what I'm thinking about. You go into some of our planned unit developments or whatnot, or condos, where they have common area, but that common area belongs to the association, not the general public. And we've had PDDs come up where they may have common area, but they're not building a park that's a public park. They may be paying Quimby fees, but that's not necessarily always enough to build a park. And I think our definitions for that need further clarification. One, just so we're understanding and the applicants are understanding. And secondly, I think affordable housing also needs more definition, because is it dedicated? Is it not dedicated? Who runs it? What do we mean by affordable housing? Just putting in an affordable housing unit, and we can see in San Francisco and other beach cities, somebody moves in as a law student, they're affordable. They stay there 30 years later, they're making, $500 million, and they're still in an affordable unit, and there's no oversight. And we've lost the affordable housing component of that. So I just bring that up because these will be the regulations for the city here.
We haven't generally created public parks out of PDs. Usually if somebody's creating a park, it's a requirement that they create a park off-site or that they leave a portion of the PD open for public use. But I don't believe we've created parks. We did create dog parks, but they were paid for usually by the association or the people, and they're open to the public, but the maintenance of them isn't public, which is one of the attractions of them for the city. So I don't know that we still would require people to pay Quimby fees.
So my point, just to get to that, is to make sure we don't say open to the public, or if it's open to the public, that it's defined what that means. Because open to the public has a huge, the Grove in LA
Is open to the public.
Disneyland is not.
Right.
You're right. So it's just being, I guess, clear in our definitions is all I'm thinking. And maybe I'm picking hairs, and I don't mean to pick hairs, but I just want to be clear on what we want from this.
On page 3, if we're moving on from open space, number 7, Plan Development District shall respect the existing street grid so that entrances to the development or streets within the development align with the existing street grid. This is something that was of much discussion at the subcommittee, and just wanted to get your feedback on that. Number 8, what it's stating there is, again, Commissioner Woods brought up the topic of affordable housing and defining that, making sure that we're clear on that. One of the things that we wanted to state is that a planned development district could be used for affordable housing developments. Density could be increased in accordance with requirements in state law. And there is existing language in state law that does allow increased density for affordable housing projects. And essentially what we would do is, in those situations, look at the language in state law for density bonuses for affordable housing. And so those are the other changes that are proposed under Section D of the document. And then Section E goes on to public benefit, if you're ready to move on to that discussion.
Just going back, and there's a definition of affordable housing. We probably do need to say deed restricted affordable housing.
Okay.
Because at least there's a term, the deeds would restrict it.
Okay.
For a specific purpose, and usually these days affordable housing has a nonprofit. And you might want to say deed restricted affordable housing with a nonprofit general partner. owner or general partner. Some affordable housing may be owned by a corporation or by someone else, but the managing general partner will be a nonprofit.
I have a question about number 7 on page 3, the existing street grid. So in the case of Mesquite, would it have to go, in what we were discussing this morning, straight through as opposed to meander?
No, it doesn't say that it has to be straight. It just says connect with the existing street grid. And so,
No, it doesn't have to go through? It's respecting it.
yeah, correct.
That's a very broad
correct.
term,
And
isn't
again, we had a lot of debate on this topic, as you can imagine. But, you know, I think there are good things with connecting with the grid. I also think there's great things that can happen when we do traffic calming as part of that. And so allowing the streets to meander, I think, would be a positive thing.
Allowing,
Yeah.
but not requiring. Because Mesquite, to me, should go straight through, and you don't have to slow down with all those houses in the way. But that's, I guess, at least an option, according to this.
Mesquite's not an existing street.
But we're not,
That's
we won't discuss Mesquite in this.
I'm not discussing
in
that
this
project.
context. We'll use
That was just
as
an example of how much I love Mesquite.
I would have to say that I would support number 7, and I can give you some prime examples in our city where we've approved PDDs. And what happens is they've done, instead of the streets coming in together, they've been offset, and that's really actually a very unsafe thing to do and not a safe thing to do whatsoever. So just having the streets come in at the same angle, I think, is very important, and that's how I read number 7. So I see number 7 as relatively important to keep.
And we could say something like through streets are encouraged, but not
Required.
not required. It at least gives warning to the applicant.
Okay. Section E, public benefit, is something that is brand new to the Plan Development District Ordinance. We've had it existing as a policy adopted by City Council back in 2009. But what we're proposing to do is to actually incorporate that language into the ordinance itself. And so what we have proposed is essentially the language that we have with some modifications to that. One of the things that the Planning Commission Subcommittee wanted to make clear is that public benefit is over and above the standard requirements that would be required of any development. And so we have that statement, I believe, a couple of times throughout this portion of the public benefit. We also had a discussion about sustainable features, that it needs to be over and above what would be required under state law or the city's adopted solar policy that we now have in place. And committee members, I can't think of other things that we'd wanted to mention about this section.
I think off-site is the same. If we were requiring off-site, it would be above.
Over and above. And again, that would apply to any of the things that are accepted as public benefit.
I have a suggestion on item B on page 4 about sustainable features. I actually think it needs to be the higher level of LEED certification. The lower level of LEED certification in California is almost like meeting Title 24. And I think it really needs to be the higher level, and we need to say gold or platinum.
Okay.
I agree with that.
Any other comments under public benefit? If not, moving on to application requirements, section F on page 4. Under number 1, as I talked about this morning, this is a brand new requirement. that for plan development districts, they would be required to file a pre-application first before they file their formal applications. That would give us the opportunity to review those from a staff perspective, identify any issues in terms of compliance with either the general plan or the code, and then also gives the public and the Planning Commission an opportunity to see a schematic site plan and offer comments on that schematic site plan.
Flynn, as we discussed, I think the same constraints language, preliminary constraints language should go here that we had in the golf course conversion ordinance, and also because it's a zone change or a general plan amendment, we also need to require meetings with the public.
Oh, yes, absolutely.
So we need some kind of process language on both of those.
Okay. Okay. One of the things that was also a recommendation of the ad hoc committee is under 2B, the applicant's required to submit a project justification statement, and we would require this as a justification letter that they submit to the city with their application. And so that was a recommendation of the ad hoc committee. And one of the things that they would need to address is how the architectural form and site planning is superior to that which would otherwise result from conformance to the standard zoning district requirements. So Mr. Hirschbein, there's that language that you had asked about earlier. If there are no other questions or comments on section F, section G is the findings section. This is something that we've not had as separate language in our plan development district ordinance. In the previous ordinance, it referred you back to the criteria for approval of conditional use permits, and that sometimes became a little bit confusing. And so what we are proposing here is that we have separate findings that would be made for plan development districts. And so these are specific to plan development districts. And so those findings are listed as 1 through 7 under section G. And so in our staff reports, we would have an analysis of the conformance of the project relative to the findings and criteria that you see there in that section.
A question for our new attorney. Have you seen other findings in other jurisdictions on plan development districts? Do you see anything that we've missed?
I have not seen anything that you've missed, Madam Chair, members of the commission. Yes, whether you call them planned unit development, planned community development, planned PDD, or any of those others, yeah, they generally have these type of findings, and again, they're pretty general findings, you know, consistent with the general plan, you know, layout orientation, you know, the public benefits, you know, that's generally consistent. You see that in most of these ordinances, and these would be in accord with that. Ultimately, at the end of the day, it is a legislative determination, and so, you know, if you make these findings, then the city will go ahead and approve it. If you can't make those findings, then you use the legislative discretion and say, no, we won't approve that.
Flynn, if we could make all the findings, but we didn't want to approve it legislatively because we hated it. I just use it one reason for non-approval, which we don't usually say. Would we be required at all to approve something if the findings could be made and the project is something that the city doesn't like?
If I might clarify what you mean by we hated it, meaning that you find that the density is inappropriate,
location, use,
or things like that. There's language under the criterion findings that would allow you to say the findings are not met, and that would be your method for not approving the project. So I think that the findings are broad enough that you can make a case that if you do not like a project because you do feel it is too intense, too dense, there will be traffic impacts, things like that.
Not architecturally superior.
Correct. Then there is, you would find that the finding is not met. Moving on to section I, one of the things that I wanted to do as a staff member was to clarify how we do modifications to plan development districts, because it's not always clear what the threshold is in terms of something that needs to come back to the Planning Commission versus something that can be approved at a staff level. And so what I've done is identified what minor modifications would be to a plan development district and what major modifications would be. So I just want to point out that this section is is new to the ordinance, not something that we have there completely in our ordinance currently. And what I'm talking about is where there are minor adjustments to things such as footprints, that they're moving the building so that it's 11 feet away from the property line instead of 10 feet away from the property line, or the landscape buffer, the shape of it changes slightly based on the layout of the parking lot or something like that, where they're not decreasing the amount of landscaping or the landscape area, they're just making adjustments to it. Those are things that I would define as a minor modification that would be approved at a staff level. But anything where they are increasing the intensity, the number of units, or attempting to decrease parking requirements below what has been approved or what would be allowed under code, those things would be major amendments that would need to come back to the Planning Commission for approval. So again, the intent of that section is to define what can be approved administratively versus what needs to be approved by the Planning Commission. Under section J, termination of proceedings, there is language that we've added to the end of that statement, and that is relative to the timing of tentative map approvals. The idea being the recommendation of the committee that tentative map should be approved in accordance with the entitlement or in step with the entitlement. That if we extend an entitlement through the extension of time process, that the map should also coincide with that. The one caveat to that is if the state in the future does any extensions, automatic extensions of tentative maps, that's not something that the city would have control over. But under regular circumstances, we would time any extension of a tentative map to match that of the planned development district itself.
So if you have an extension of a tentative map by the state, and they extend it for something like they did recently, 9 years.
Yeah.
And the PD has terminated, but they're entitled to record the map as long as it met the original conditions of the tentative map, then what do we do? City Attorney.
Well, really, the better question is, what does the developer do? But in land use, we have a lot of these things that sort of independently track, and then all of them ultimately meet up for a final project. What the Subdivision Map Act says is you cannot sell, lease, or finance individual lots until you've recorded that final map. Now, if somebody went forward, got a final map recorded, but the above surface entitlements to actually build the project have expired, arguably a developer could still individually sell or finance or lease those individual lots. But for practical purposes, it may not do a whole lot because they're going to have to get the other entitlements to actually build something on that. So while technically some of these things could be approved and might be able to go forward a little bit, to actually have a true unified operating project, everything's got to be brought up to speed. So if the state law should extend tentative maps for 9 years like they did before, but the PDD was allowed to expire, that developer would still have to come back and get an extension or get a new PDD if it's expired and not been extended. So.
Madam Chair, let's pose this question of our city attorney. I'm going to put him on the spot here. If we were to propose language that said something to the effect that a final map for a planned development district shall not be recorded if the planned development district entitlement is terminated. Would that be appropriate to put in this section of the document? Or is this something that we would want to think about?
We could think about it. I'm not sure if our ordinance should say you can't record a map if you don't have this other entitlement done. There may be some issues with subdivision map act compliance and stuff. We can talk about that. We can
Okay.
Would you?
Yeah.
Okay, so we will look at that issue then. Let's see.
Madam Chair, maybe excuse from chamber for just 2 or 3 minutes.
Certainly. Do we need to take a break?
Brief, literally.
Why don't we
2
take
minutes.
a 5-minute break? Planning Commission is called back to order. We had one comment on findings that came up informally, which was to see if Flynn could draft a finding on better architecture than we would have otherwise gotten. So we'll leave that to Flynn for some drafting.
Okay.
Wording can you could base the wording on, the wording at the top of the page there, under 5. Site planning is superior to that which would otherwise result from conformance to standard zoning district requirements.
Okay. So we will go ahead and note that.
And one thing that are we on page 7 yet, Flynn?
Yes.
Number 3 and 7 is, in both Flynn and I thought that language was badly drafted. It came from the original.
Correct. And that's that last part of the
Right.
sentence under number 3 that says, shall not terminate if construction has commenced prior to the termination of the DDA. And typically, with the termination of a development agreement, construction is completed. So what we would want to do is revise that language there.
And maybe shall not terminate if if appropriate levels of construction have been completed during that phase, or.
I would also point out, Madam Chair, that typically in a development agreement, there is the standard section of it that talks about annual review, checking out the project, making sure they're making progress. There's a whole process prescribed in the agreement and the statute about how to terminate or something.
Can you help Flynn with a good drafting of that so that we don't
Certainly.
extend this forever?
No problem.
With that, we didn't really have any other changes other than the addition of definitions that we need to support the proposed changes, and you have those at the bottom of the page. We've already had comments on the definition of affordable housing. We also need to make some minor revisions to our definition of lot coverage. And then what we have not had in our code prior is definition for open space, common open space, and private open space. And so those 3 definitions would be brand new. As we discussed this morning, we identify what may be included in open space and what cannot be included in open space. Just like the recommendations of our golf course repurposing ordinance, things such as driveways, parking areas, et cetera, would not be included in the open space.
So
let me just comment. Sorry, Commissioner Maruzzi just made the comment about swimming pools. Typically, in the past, we've included recreational facilities as being included in the open space because they are recreation facilities for residents. And so we have allowed swimming pools to be included as part of that.
I thought these were private swimming pools they were talking about. These are ones that are associated with a particular unit. This is
and what we might want to do is perhaps clarify that common swimming pools would be excluded from the would be included in the open space requirement.
Individual lot swimming pools would not.
Okay, yes, that's what I'm trying to say.
Individual lots.
What Mr. Maruzzi was saying is that common swimming pools could be included in open space, but private swimming pools would not.
Wouldn't private swimming pools be included in private open space?
Yeah.
If you choose to do that, yes.
I would think that.
To be part of the backyard.
I think they're usually part of the backyard, and the backyard is usual, or side yard, and the side yard is almost always considered private open.
Okay, we can make that change if you would like to do so.
I have a comment, and it goes to this common open space, comma common, and it says, or members of the means open space that is designed and intended for the common use by residents, guests, or members of the general public. So you could under that, because it says or members, could you therefore exclude members of the general public? And I'm thinking of like a swimming pool.
Yes, you could.
Under this definition.
We have approved projects where the amenities of the project are restricted to residents and their guests. There are also examples of projects that we've approved where we have in specific cases stated that those amenities need to be open to the general public.
Right.
To give you an example, Miralon and the Groves, we said that has to be
Serena
open.
Park, we had some open space to the general public, and we had some that was not. So would this then allow for both cases?
Yes, it would. And I think Commissioner Hudson said we should say and or members of the general public.
I think we're back to, are we back to gates?
Yes, this would be a good time to discuss gates. Again, another topic of much discussion at the ad hoc committee level as well as the Planning Commission subcommittee. I gave you the handout from the city's general plan in terms of the language that exists currently. This is in the community design element, and it says, prohibit gated community entries and perimeter walls around entire neighborhoods. Instead, provide privacy through design features such as meandering streets, ample landscaping, and house placement that provides privacy and exclusivity. The question has been, should we include language about gates in the Plan Development District Ordinance as part of these changes that we're making generally? One of the things that I would mention to you is this something that you want to provide in the zoning code as a general requirement for all developments? Should it be specific to plan development districts? And again, this is something that we're looking for input from the Planning Commission.
I think if I can, I think it should be in the zoning code because it really should apply universally and not just to PDDs. And particularly since we're going to have so many fewer PDDs once we get our small lot ordinance on the books, that this is something that we should move to this general zoning code, and it's going to need to have. I'd like to make it more mandatory because we've been overriding it in various cases for some good reasons, and we need to put some specificity to those reasons here. We should cite that you have to have very good reasons for having a gate, such as you're right next to the convention center, and you're thinking of where my house is, or a senior citizen project, perhaps, or something, or if you're in a very high crime area that can be documented, or something, some things like that. Not for reasons of creating exclusivity. I think it's for potentially for reasons of safety or things like that.
Madam Chair?
Yes.
Just to address what you're saying, Commissioner Calladine, I'm just wondering, well, let me see if I can rephrase that. I'll get back to you.
Go ahead and wander.
What I was thinking is, I'm just worried about the timing.
Yeah.
Whether or not it's going to take forever for the zoning code to be modified, whereas we're dealing with the Plan Development District now. So let's put that aspect in the Plan Development District that we hope will be approved shortly. And then who knows when the zoning code is going to be modified. So that was really what I was trying to think is the timing.
Okay. Really, it's a general plan amendment, isn't it?
No, I don't believe that we need to do a general plan amendment. You can make changes to your zoning code to implement the recommendations of the general plan. And so if what you're doing helps to, again, achieve the goals of the general plan, then you don't need to modify that language. What I would tell you in terms of the timing is that if you see this as being an issue related to plan development districts that you'd like to see in the zoning code, there's no reason that we can't include that as part of this ordinance update. As you'll notice, I'm making changes to other sections of the code, primarily the definition section, because those are necessary to implement these recommendations. So I see that there's a couple of different options. You can either include that language directly in the plan development district ordinance itself, if you want it to apply specifically to planned development districts. If you'd like it to apply generally to all development, all residential development, then we can propose that as part of this overall series of changes.
That's a better idea.
What do other commissioners think about that?
As long as it's, I think as long as we're doing it at the same time, it's fine to do it generally. And I do think that saying that it's not for purposes of exclusivity, that, but it would have to be for demonstrated high crime or a traffic, a traffic burdened area. I mean, those are the only two reasons that I think I can think of two projects where we've allowed gates later, and they included both one or the other of those exceptions.
I would have an issue saying high crime justifies a gate, because the studies will show you the minute you put bars on the window, whether or not you have crime, the presumption is you have crime. So and we really, if we want to form a crimeless community, both visually and spiritually, as well as actual crime, I think the idea of gates to stop crime is not the right signal.
Do other people agree that the only reason for gates is a parking-related issue?
I think we want to bring the language back and see what it says overall, rather than. I've done quite a bit of research on this recently, and there is some evidence in some cases that gates do actually reduce crime or prevent some crime. There may or may not be better reasons for doing that, and I'm concerned as well as if we don't. That there's a public perception that gates create, that gates may help public safety, and without them, projects might not be viable in areas where we would like to see some projects. We've been told that about some of the areas in town, so it needs some more discussion. I don't want to say we do that yet. There are a couple of other exceptions that we might consider. I certainly think that senior projects might be, and where you've got structured parking. That's another issue that there's not very many places I think we have residential, but we might have them in the future. And well, like we've got it, I guess, for the Diplomat or one of those projects where we've got under the condominium building parking. I think they have gates there, and that's a logical place for it. So we need to think about it a little bit more before we. Come up with our list of potential exceptions, but in general, the burden should be on the gates proposer to prove they're necessary.
I'd agree with that. We reviewed a case recently where there was the issue of homeless people utilizing the swimming pool. Mm-hmm. So I think we just need, or council needs, discretionary ability. But I think you're right, Commissioner Callardine, that it's the burden of the applicant to really prove the need for gates.
Right. Why not use the language that is being used for solar that has to be proved why they should not? I mean, there was actual language that was already approved.
That's where I think we're going.
But that language exists. We can just stick it in there.
The burden essentially is to prove that you can't do it.
Yeah, whatever the language is for the solar.
What I will do is I will come back with language for you all, and we will look at doing this generally in the zoning code as opposed to specifically only in the Plan Development District section based on your comments here today. So we'll go ahead and do that.
But do we have more comments on this in general? Summing up where we are, things that you want to see changed in addition to the comments that we've made today?
Madam Chair, I just have a comment. I'm not quite sure, I don't have a solution on where to put it in here, but, there are some advantages when we've had these PDDs come in where they gate them and then the road structure is substandard to a city roads and then thus become private roads, which there's some benefit financially to the city to that, and there's probably some benefit aesthetically. and whatnot. I don't know if we're trying to preclude whether or not you have gates is irregardless. If we still want to allow the ability to have private roads, or we want to make PDDs always have public roads.
Those are separate issues. Oh, I've always seen those as separate issues, that there are lots of places where you have private streets that you don't put gates up.
But we should address the private-public road issue. And maybe, I don't know that we have a solution to that. It's the benefit, if you have an association, your roads are always, they can be in good shape, even though the city doesn't have funds to fix their roads. There's a benefit, and there's a benefit to the city to not pay for them, but I think we have never addressed public-private roads when we've looked at a PD. We've always assumed they'd be private.
Generally, in certain cases, we have required them to be public roads on certain types of applications. But that's certainly something that we can look at and discuss.
And probably the assumption is that the roads are private unless the commission and council require them to be public.
Yeah.
If you look at several of our PDDs that have been approved, what you end up with is, let me go back. When you look at a single-family residential, traditional single-family residential per our zoning code, you have lot coverage and setbacks. So front lawns are not considered open space. They're just part of the setback and the lot coverage. When you get into PDDs, that's all played with. That's all kind of get out your wand and play with it. And in some of these, we've just seen garage door after garage door after garage door, no sidewalk, a setback of the front house that's 10 feet, and we call that open space. And then what they've also done is they've reduced the street widths and whatnot, reduced on-street parking, and done other things to create more sellable area for these PDDs, more sellable land and less actually public area. I don't know as this PD, and I know it's gone through a lot of iterations, addresses some of those issues. You can increase the open space, but it still doesn't change your street view of that, especially if it's going to be a public street, or even if it's a private street that's not gated and open. It's still a Google car driving by taking a picture representing your city in that particular area. So I don't know if we want to address that, if we want to leave that as a case-by-case basis, if it's something we do or do not want to put in regulation.
We certainly put that into this draft small lot ordinance, which we've got to review now against what we've done here, but maybe we should take a look as to whether or not we should include some of those items here, because we did require, in that we required certain kinds of street width parking, had very clear standards. And if this doesn't include single-family home lots or a subdivision of single-family home lots, we may need the standards only in that ordinance and not in this, but I think maybe we give that back to the subcommittee to consider and bring both back next time. It's a very good comment, thank you. Anybody else for comments? Everybody else want to go home? You have notes. Do we need to take any action, Flynn?
No, this is just a discussion item, so there is no action to be taken here today.
Yeah.
What I will do is we will want to go back to the Planning Commission subcommittee to work on your comments that have been suggested here today. And then once we have a good draft, we would probably want to invite our ad hoc PDD committee to attend and sit down with us and review this in some type of a study session. So I think that will probably be our next step.
And since we have a member of that committee here today, Marvin, did you think we've missed anything?
Well, yes, but I didn't know about this until this morning, and so I was reading this while I'm listening to the other discussions. I think there's some detail stuff. I mean, there's some big area stuff that, Lynn and I and others have talked about, but I'll try to
draft some stuff up. You know, what was the one that, there's just some details on how the PDD works, how it works on the map. Is it zoning, is it not zoning? And those kind of things that are in here that I'll work with Flynn on separately. Well, the one thing I think that you guys would like to contemplate is that single-use housing issue. At least I think you need to open that up for affordable housing. But there's a lot of stuff that could be in a PDD that might be a, you know, where you have a, oh, I don't know, C1 and R4 zone or something, and you're trying to do something with a condominium project or something. It's more or less a single housing type that would have to be a PDD. So yeah, I think the intent of this was to exclude the small lot stuff. That was the primary angst as we were going through this. So, you know, there's a few things like that. You know, I would disagree with alignment of streets all the time. When you line a street, you often end up with a traffic light. So, you know, there's some details on, you know, some of this sounds better guidelines than ordinances. With a lot of what is happening, I don't think you're going to get a lot of PDDs. And while that may have been one of the goals, the vacuum still is in the other zoning regulations that aren't there yet to follow up with where we have been doing PDDs, because we don't have good standard. We don't have a good zoning ordinance for condominium projects. It was one of the reasons the PDD got invented in 1967. I tell you the date, but I don't know that. Is because all of a sudden this new thing called condominiums came up, and we have single-family zones where they wanted to do those. And that's why, you know, if you look at the projects along Sunrise, you know, our first public benefit was we converted a frontage road requirement that was going to exist on Sunrise. If you look at Sunflower Villas right there at Ramon and Sunrise, you see the frontage road, and that was going to go all the way up to East Palm Canyon. And they came in and we said, no, you don't have to put the frontage road in, but just make it all landscape. You know, and so, and they wanted to build so bad that they would do that stuff. And that's kind of where the PDD, I think you're going to lose some of those opportunities to explore, you know, the next 20 years or 30 years and what's that going to bring. But that's okay. And there's a few details, but, you know,
okay.
We've got ways to go. Thank you for asking me.
This item is closed. We are moving to Planning Commission reports, requests, and comments. The only comment I would have, Flynn, is that we set up our subcommittee meetings, so we move these items through rather quickly.
Okay.
And other commissioners, do you have comments? Commissioner Kellerden, is your light on? Commissioner Hudson?
Yeah, I think I was assigned to a subcommittee recently, and I'd just like to remind staff that I'm going to be basically gone for the month of May in terms of when that subcommittee starts, or anyway.
In fact, I think I was asked to join a parking subcommittee.
Yeah.
Is that yours too?
And actually, what happened with that is staff, our city council liaison representative asked us not to move forward with that right now. And I forgot to let you guys know that.
Right, another subcommittee.
They're not quite prepared yet for what might have been a request from one or two city councilors. Flynn?
I don't have any comments other than from our study session this morning, we will go ahead and continue that item to April the 25th, and we would like to start that at 10:30 in the morning just to give us adequate time to go through some of the issues relative to that site plan.
We don't have two items, though.
And
I wanted a little more time so they didn't bump into it, but we only have one item, so 10:30 I think is sufficient. But if we got the same number of people coming in to testify next time, and we might, we need some time for them. And if we end early, great.
Just get extra lunch.
Okay, this commission meeting is adjourned until April
25th at
25th
10:30
at
a.m.
10:30.